Have you ever felt secure about an agreement, only for its terms to suddenly shift without your explicit consent? It can be unsettling when the rules change in the middle of the game, especially concerning your job. Unilateral contract changes, where one party alters the terms of an agreement without the other party's explicit consent, carry significant risks primarily because they can leave the non-consenting party vulnerable and without the protections they initially believed they had. This undermines the very foundation of a contract, which is mutual agreement. The core reason these changes are risky stems from a fundamental legal principle known as mutual assent, which means both parties must agree to the same terms. When one party tries to change terms alone, it challenges this principle. Employers might attempt to change things like your job duties, compensation, benefits, or even termination clauses. The risk is that these changes could be detrimental to you, reducing your pay, increasing your workload, or eroding your job security, often without you having a real say in the matter. This is particularly relevant in at-will employment states, where employers have broad rights, though not unlimited, to change employment terms. To protect yourself, you should first meticulously review any employment contract or offer letter for clauses that explicitly permit your employer to make unilateral changes. Many contracts include language allowing the company to modify policies, benefits, or job roles with notice. If such clauses exist, understanding their scope is crucial. Always ask for clarification on any proposed changes and consider whether you can negotiate alternative terms or if the change is so substantial that it may impact your continued employment. Documenting all communication about changes is also an important step. It is also worth noting the legal concept of consideration, where a change to a contract typically requires something of value to be exchanged by both parties. If an employer makes a significant change without offering you any new benefit, that change might not be legally enforceable. Furthermore, in some cases, if changes are extreme enough to make continued employment unbearable, it could be considered a constructive discharge, meaning you were effectively forced to resign, potentially triggering certain legal protections. Understanding the inherent risks of unilateral contract changes empowers you to proactively protect your employment terms and financial well-being. By staying informed and carefully reviewing your agreements, you can better navigate workplace shifts and assert your rights, ensuring that your professional journey remains on solid and mutually agreed upon ground.